is terminated. So at that point of time, one of the party has suffered. Who suffered is a matter of arbitrator to decide that or conciliator to decide. But both the parties have suffered or one of the party have suffered. Here the problem is that the government is first saying 30% of amount. Even suppose as a good contractor or as a good industry practice or whatever in the looking at the future business, I accept 30%. But really we are getting 30% is a question mark. Look at the proposition there, because it is an ongoing arbitration or ongoing as conciliation when claim and counterclaim both are existing. Both are existing. And when both are existing, look at it. I am asking 100 rupees as a claim. The opposite party is asking 50 rupees as a counter claim. What they say, from 100 you deduct 50 rupees without adjudication. And on that, another remaining 50, you will get 30%. Now, understand this gimmick. Here I am using the very harsh word of gimmick. Understand this gimmick. We know in a construction industry that it is always contractor, he put forth his demand. That demand is becoming a claim. And when other parties knowing that, okay, contractor's claim is coming 100 rupees, let me put 120 rupees counter claim because my 120 minus 100, I don't have to pay anything. Who will control this proposition is my question mark. I have no problem with A and B, except that the percentage component and interest component. I have a very strong apprehension or the objection on the proposition C, because other party is bringing counter claim in the time when we are submitting or going to the arbitrator. They are not telling us in advance. They are coming as an afterthought process. They, without understanding, without doing delay analysis, while giving the extension of time, say extension of time is giving with a reservation of right to levy LD. Whether they have a right to levy LD, who will decide? Nobody will decide. So the moment I raise that 100 rupees is my LD, this scheme says deduct 100 rupees. Rightly or wrongly, they have levied. So scheme C is not acceptable as per my analysis and my proposition. Otherwise, you will fall into a trap. The moment your ongoing arbitrations are there, or not arbitration, ongoing demand is there. I say, don't say even the claim, because what they say that it is not an ongoing arbitration process. You have just submitted your statement of claim. They have submitted their statement of defense. In statement of defense, they put a lot of claim. Now, when I'm putting a statement of defense as a government organization, I know what is the amount of claim to me. And I know about this scheme. So what I will do the mischief as a government organization, I will put up more counter claim than what you have demanded. Or I will put up such a counter claim in a manner that you get hardly any peanuts. Because residual, again, from residual amount, you are getting only the 30% of the amount. And that too without interest. 6% interest is a future interest. Look at that proposition. And future interest, that today they don't have to get the money from anywhere. They will use your money. They'll say, we are paying you 6%. Why you are in a hurry to get the money? So my money, which is a less amount, they will use it with the 6% interest. So I'm losing a lot in that proposition. If my claim is reduced, why not counter claim? Read it properly. The amount demanded by the contractor less counter claim. Counter claim is not reduced. Counter claim is given 100%. So what will happen? More and more litigation will start. What contractors will start doing? They will start raising unnecessary wrong claims because they know counter claim is going to come. So I will ask the claim for my opportunity loss. I will ask the claim that idle machinery was haywire, and n number of such claims which are otherwise legally not substantiable. So scheme C, it should not be taken as it is what is proposed by the government. I am against that. Of course, it is subject to what we all of us will discuss, because otherwise you will not get anything. The moment counterclaim comes, you know, see, I can give you one example. There was one arbitration. It was an American company versus municipal corporation, Bombay Municipal Corporation. And our claim was of 8 crore. Against that, corporation came in the arbitration in their statement of defense with a 1700 crores counterclaim. With this scheme, where I stand, that American company got so nervous that what is this all going on? Because they have a different law in America as compared to us. We don't have a PIL 95 where if you fail in certain percentage of claim, you have to pay revenue to the government for Fraudulent Claim Act. We don't have that, so I can put any amount of claim. And that is what the government will do here on ongoing arbitration in statement of defense. Because there is no date given. What it says about 22 September is only for A and B. C is an ongoing process. Even today it is ongoing process they are talking about. So statement of defense already have a counterclaims. If 100% counterclaim you are deducting from my claim without adjudication, without finding the justification where I stand, and from that you are giving me only the 30% of the claim. And that too with the interest of future interest, if I don't pay you in time, 6% only. So what I said and what I suggest, that point C required a rigorous introspection, a discussion, and we have to reach to some reasonability of the things. We can't blindly accept this proposition according to my analysis and my thinking. The next one is a D, where the work is going on. And look at the MOU or the agreement they want us to sign. They say that if you have reached to a conclusion, of course, this also I do not agree, but I am coming from backward side, that all the claims, all the dispute, all the differences arising out of this contract is settled. So all my future claim also will be settled. They will go on asking me doing COS, they will go on doing the delay. My project is going on. And at the end, even though I have suffered, because I have signed that MOU for the ongoing claim, all my future claim has gone. How can we sign that way? Up to that point, up to that date, yes, I agree, up to that date, yes, we should accept it, but not in the way they have proposed it. I have a similar objection on point D also, which I have objection in point D. Point C. Point D also same thing. Counterclaims are coming up because I know my counterclaim will be 100% recovered. And then whatever residual remains, I will pay how much percentage? 20%. And future claim all gone. How can it be called as a Vishwas? I don't see Vishwas in these two propositions. Point C and point D is not in beneficial or not to be accepted by the construction industry. We have to propose for ongoing arbitration and ongoing litigation a different methodology altogether. Because this way, construction industry will not be benefited. Otherwise, all the government officers will be in a comfortable zone. They will say, okay, he has asked 100 rupees, raise 80 rupees, 90 rupees claim, counterclaim. It is very simple for them. Nobody is going to ask them why you have put up 90 rupees. And as per this proposition, 100 minus 90, 10 rupees. On 10 rupees, 20%, 2 rupees you take and go. No interest on that. So ponder on these 2 points. C and D are to be ponder it very, very rigorously by all of us. Point A and B, I have a proposition only that instead of 80%, it should be 90%. Point B, instead of 60%, it should be in the range of 75 to 80%. As far as interest component is concerned, again, we should strongly put up our point that it can be negotiated in the range of 9 to 12% and not less than that. It can be more than 12, but cannot be less than 12. Because as Dr. Awasthi said rightly, today lending rate is 12%. How government can tell us that what is the thing which we are getting from the market is reduced by government just for the purpose of this. Now, people say that we want our legitimate claim and we don't want benefit. I agree. I also don't want benefit from this. But how, when you are getting benefit government is taking by introducing counterclaim. If without counterclaim they come up with this proposal, we can argue on the percentage. But counterclaim, we blindly, I have to deduct it from my claim. Then where you are getting your legitimate claim? I fully agree that I don't want any benefit. You give me 1 rupee today, I am happy. I am not interested in getting 10 rupees after the getting decree with the interest. No construction industry professional is interested in that. I say we mean business. We don't mean litigation. I came across many organizations. They say that, Madam, जाने दो, हमको नहीं चाहिए, हमको arbitration नहीं करना है, हमको litigation नहीं करना है. I have come across many like that. But when we talk about an industry at large, not a few members, we are talking about at large. An industry which is growing fast, an industry which is going to face so many infrastructure work. Are we not required to put it into a comfortable position, in a position that we really get a Vishwas? According to me, C&D is not giving me the Vishwas, because that is giving me a propositions that if I ask 100 rupees, you are going to ask 90 rupees. I am ending up with 2 rupees only, while my legitimate claim is 7 to 8 rupees. And when ongoing work is going on, take my words, I don't know if all of you will agree with me or not. Many of my clients, they are putting up a just a legitimate minimum optimum claim. They say, madam, nahi, humko to itna mil jaye to bhi bahut hai. Even if I can legally justify their claim of 10 rupees, they tell me to put up 7 or 8 rupees. So it is not that we want to take benefit. I'm not in favoring of taking the benefit. I'm only telling you that look from the larger perspective. That is this scheme, C&D, is really going to benefit us, or it will become like a bank guarantee, which is invoke bank guarantee without demur. We have suffered because of bank guarantee a lot. With the good help or work done by the BAI, we are coming out from bank guarantee problem. Slowly and smartly we are doing that. But what is this? Now somebody is telling me that 9 to 12% compounded. Why compounded? Then you are taking benefit. If I say government is wrong in putting their counter claim, at the same time, if I say 9 to 12% compounding, is again I am taking the benefit. On one side, we are saying I don't want benefit. Then why to have a benefit through 9 to 12% compounding? Even if you look at last so many years arbitration award or court decision, not a single award you will find with the compounding interest. Rarely you will get any award like compounding interest, which you will find at the end when it has gone to the court has struck down that proposition, that no compounding interest, only a simple interest. So these are my absolutely personal view. It has nothing to do with anything. So what I say, that whatever is fair and just in the interest of the society at large, not an individual, I don't want to go with the individual organization or that. What at a large to construction industry it is beneficial. What at large is beneficial to the society so that the fast development of infrastructure can take place. We should propose that type of thing. And for the amount which is already paid to you, you should feel satisfied. No interest should be demanded on that. I'm of that opinion. When we talk about the negotiation, when we talk about the conciliation, when we talk about the Vivad to Vishwas proposition, we should not become a greedy that amount should have been paid to me in X month. They paid me in Y month. What about X to Y month interest? Forget it. Forget about it. If you have received the money, you have received the money. Forget the interest on that component. But what you are yet to receive, yes, you negotiate between 9 to 12%. You negotiate on your claim component, but not by adjusting the counterclaim. I'm strongly against considering the counterclaim. If you want to consider counterclaim, then let them justify their counterclaim first. Without justification, because otherwise it will be a process that I as a government engineer, because I have worked in government. I was class 1 officer in government of India. So I know how we work. I get my salary every month. I don't lose anything. What I have to do is put it, levy LD. I'm not losing anything on levying the LD. But I have safeguarded myself from any inquiry or anything. Now that LD proposition will be deducted from me, rightly or wrongly you have levied. Who is going to ask this question to those engineers who are going to do this? Sometimes engineers are doing under pressure also. I have seen that also because I myself have suffered that, and in that pressure I have resigned. I left that job because I said I can't work under pressure. If you say that don't pass this extra item which is genuine, if you tell me don't give EOT without LD, even if it is genuine, I can't work under pressure and I resigned it. But everyone is not lucky as I am because my family background allowed me to do so. You can't leave the job every time. You have your family. So engineer also works under pressure. We have to keep that in mind. We can't always blame, we can blame the policies. We can blame the schemes. We can blame the government organization's methodology of questioning the engineer. Because the Vishwas is living there. We don't have Vishwas. And because we don't have Vishwas, we have a Vivad. So what I say that let us introspect and have an open house discussion without any reservation in the mind on the point C and D. Because that is the only, and then also along with this, my another proposal is that let us give a proposal to the government that how the ongoing resolution mechanism should be done. Because that will save a lot of time. Today we in one contract, we have a multiple arbitration. I have faced one contract where 5 arbitration was done under the same contract document. 5 different arbitrators. 5 different propositions, same type of issue, and all the 5 different award were there. So why to have a multiple litigation? We have to propose some scheme to the government that avoid this multiple arbitration by removing those type of clauses which force you to go for arbitration. Why I'm saying force you to go for? Because they have given a limitation of time. That within 30 days, if you do not agree, you should invoke the arbitration. Otherwise, your right to invoke arbitration is gone. So what we have to propose is that how the future contracting administration should be done. What should be the clauses into the contract should be included by which we can avoid multiple arbitration. We should have a fraudulent claim proposition into the contract. Of course, CIDCO had introduced such type of clause, but that was one-sided. Again, if CIDCO put up the counterclaim, they don't have to deposit any money. But if contractor Demand 100 rupees, 10% of that money should be deposited with the CIDCO in the revenue till the arbitration is going on. It's just like a court fee. They said how that it is their concept that if contractor has to give the money, their amount of claim will reduce and it will be to a require only. That is what is that. But I say, okay, we can have that type of system, but that type of system should be for both claim and counter claim, not only for the claim. So that type of recommendations we can give to government, that how ongoing arbitration should be taken care, how we can avoid the multiple arbitration and multiple litigation, what should be the resolution mechanism when already dispute has taken place, when either you are in arbitration or you are in process of conciliation, how to deal with it, how to deal with the counterclaim which are going to come without adjudication, without justification. And the last proposition, what they said is any amount above 500 crore will not attract this scheme. The question is why? That is a very huge amount. Why you want that to go into the arbitration? We know that recently the Reliance got 2,700 crore claim from the Supreme Court. Why government has to avoid this? Whether it is a 1 rupees or is a 500 crore or is 1,000 crore, it should be taken care by each and every claim should be covered up under Vivad to Vishwas. It cannot be said that, no, up to this claim we will look into, beyond that. It means that, see, according to me, it means that छोटी मछलियों को आप पकड़ के खा जाओ, बड़ी मछली तो हम सहन नहीं कर सकते, वो शार्क को तो हमें खाना देना ही पड़ेगा. That 500 crores are sharks. Why they want to pressurize the middle and small contractor? And why they want to keep the big contractor who can even afford everything outside this Vivad and Vishwas? Is my questions to the participants. Now, another thing is that they should put this entire scheme to all the government contract wherever the public money is involved, irrespective of whether it is a corporation, whether it is a NHI, whether it is a metro rail or state PWD or central PWD or any organization. Whenever there is a public money involved, one should go through this Vivad and Vishwas. It cannot be restricted to some of the department only. A blanket statement, wherever the public money is involved, this Vivad to Vishwas should be applicable. And that is because they have restricted to some of the organization. And they have not included corporations like municipal corporations or Jilla Panchayat or anyone, but everywhere it is finally exchequer money. It is my money which is I'm paying through income tax. Why that should remain outside this? So that also should be included and we should discuss on this. And I will tell the government, if I have to say, that whatever is the Vivad, resolve it through Vishwas. And henceforth, no Vivad, only Vishwas. Why should we have a Vivad? Have a contract document and the process of dispute resolution mechanism in such a manner that you cannot have a Vivad at all. Resolve it amicably. So I will say that Vivad to Vishwas till date. For future, no Vivad, only Vishwas. And that is what is my view. Thanks a lot. Thank you very much.
Now, this is the question hour. Any member would
Raju sir,
bolo.
Gupta sir, there is a hand, but madam, there are a lot of questions in the chat box.
I know few of them I tried to, because while I was speaking, if I read, I can't speak. So whatever I can read, I have tried to answer it. Like somebody said, we don't want benefit. Or somebody said, we want compounded interest. I covered up those chat box questions. Most of them, wherever I can read while talking. But still, if there's anything missed out, please let me know.
Yeah, there is some. 1 minute, Madhu. There is one question was section 34 and section 37. I will read the question. Just see whether you can help. 1 second. Which is considered as court decree, section 34 or section 37? What is the answer, man?
See, none of them is called as a decree. Decree will be passed after the process of these sections. In the court, it will be hearing takes place. And when the court gives judgment on that, that is called decree, and that decree has to be executed. That is what in the starting I told you. That even today, Dr. Dave's award decree is lying in Thane court for execution. Even execution decree is passed, but still no money. Color of money Dave could not see. I don't know whether his kids will be able to see because all of them are in USA.
Yeah, madam. Otherwise, the questions you have answered, as you rightly said, it is mostly on the bank interest and the interest offered by the government.
Yeah.
Avasthi, you want to put some questions or you want to make some statement? If you want, you unmute yourself first. Then it is better if it is a question actually.
Yeah, it is.
Raju sir, some people have raised hands, huh?
Yeah, I have seen that. We are giving them time. Yeah.
I would like to ask that this particular interest part, she has suggested that 9 to 12% would be all right, should be reasonable enough to have some kind of a. But at the same time, saying that compounding will not be, will be little harsh to the government. I would like to say, madam, that all the contractors and the builders, the banks are charging not simple rate of interest, they are charging compound. In case we are so sensitive about compound rate of interest, I think we should follow the banks, because banks are basically nationalized banks and all banks. Can we not, I mean, in a polite manner, ask for the interest, whatever the house decides the rate of interest, and let it be rest with quarterly rest or yearly rest. This is my humble suggestion as far as section 4.
Sir, I agree, but when we come for resolution, when we come to avoid the Vivad and we want to come to, so it is a give and take relation. If I'm asking something or I'm giving up something, see, the few people say that we don't want to take benefit. We want only our legitimate money. So if we keep that concept in the mind, then it is a give and take relations. We can't have everything I want compound interest, I want all my claim, I want everything, then where is the resolution? When we come for settlement is always on give and take. And it should be on a win-win situation. It should not be win-lose. Here the C&D is a win and lose. Government is winning, we are losing. That is what is my proposition, that we should go with a mind of win-win situation rather than, see, if we talk legally, yes, legally, I argue in the arbitration or I do all these things, I justify by the law, because Arbitration Act itself provides the lending rate plus 2%. So that is my legal right. But here we are not for legal rights. See, if you see the resolution, they say that arriving at some figure does not mean that we have accepted the default of other party. So legally, we are not deciding this. We are deciding on the mutual cordial relations basis, on a win-win situation. If you talk about law, yes, it is a lending rate plus 2%. Arbitration Act provides that for me.
Okay, Gupta sir.
Gupta sir, unmute yourself. Anand Gupta sir. बोलिए.
Vandana ji, you have nicely explained the Vivad se Vishwas scheme. But one very big thing which I observe, we work in MMRDA in Mumbai, we work in State PWD in Maharashtra, we work in irrigation department, and similar all other state government department, particularly in Maharashtra. Since I work in Goa, and I find there is no arbitration in contract itself. There is no dispute resolution system. Now, what about those?
See, Gupta ji, that is we are at present on Vivad to Vishwas. Now, we have to come forward, as I suggested, that proposal, that why we are Vivad. So we should have a provision, no Vivad and only Vishwas. And Vishwas will come only if government is coming forward with a positive step of introducing dispute resolution mechanism. Unfortunately, not only in Maharashtra, most of the corporation, most of the government organization has deleted arbitration clause. Go to court and break your head. Now for that, long back we are telling BAI to follow up with the government, and BAI is doing that. I'm really happy to know that to introduce the clause into the contract, that there should be a dispute resolution clause, and we can propose dispute resolution mechanism. I have a couple of things, but this is not the forum to discuss that. We are today on Vivad to Vishwas, whatever the government has proposed. Otherwise, there are n number of other things related to this. Then what should be the fair contract document? What should be the provision into the contract? How the contractor should not be punished for no default of him. There is a different forum required for this.
Okay, the DL Gupta sir, you can put your questions, please.
अनम्यूट कीजिए खुद को. गुप्ता साहब खुद को अनम्यूट कीजिए.
हाँ कर दिया.
पूछिए सर.
My question with the ma'am is where I put my question regarding the compounding of the interest. When we are paying compounding interest right from the day one to our banker, apart from other miscellaneous expenses on account of stamp duty, then processing charges, and insurance, all such type of expenses we are paying, then why it should not be compounding? If not compounding monthly, at least it should be quarterly, because otherwise there is no negotiation. It is all one-sided.
Sir, that is what I replied to Dr. Avasthi, that is my legal right. But that too, when I go to process of arbitration or in court of law, here what we are discussing a resolution. It's a win-win situation, give and take. So if I am getting something, I have to leave something. If I insist on everything, then where is the resolution?
No. We are not insisting for everything. We are coming down to the 80 to 90% of the awarded amount, decreed amount. Then interest part is even in some time it is more than the claim amount. But the process of litigation is going on more than 30-40 years.
That is what we want to reduce. That is what we want to reduce.
We know of several firms, even myself also. 40 years, 35 years, it is decreased, is lying with the under 36, and even then government is not paying.
I know. Dr. Dave's award was for 4 lakhs rupees. As on today in the court, it is lying with 40 lakhs. Because of interest component. And that too simple interest. If I would have done compounded interest in that award, it would have been much more. But here we are not on that count. We are not talking legally. Legality, it is my right.
I'm also not putting it as a legal. But there must be some in between. If we are paying back to our bank and monthly compounded, it should not be less than quarterly compounded or like that.
So early resolution is the one of the way, and that is what government is coming forward with Vivad to Vishwas. But 6% is too low. I do not agree with 6%.
6% is nothing.
Nothing. 6% question does not arise to accept it.
You can get more than that in your FDR.
FDR.
Bank account.
Yes.
This interest part we have to see very, very carefully.
We have to see very carefully.
It will be more than the claim amount.
It will be more than
what we have already.
Okay. That point you will take care. Mr. Swapnil from Sangli, you please unmute yourself and put your question, please.
Yes. Can you hear me, ma'am?
Yes.
Yes. Thank you, ma'am. Basically, I'm a chartered engineer and also a lawyer. So since my questions will be coming from that background, couple of questions. This Vivad se Vishwas, as you rightly put it out, it's a very good start, at least a start, to talk with the government. Two questions. Number one is there is a fighting of a case which has already adjudicated by the district commercial court, where they have awarded a sum amount, say rupees 100 rupees. That has been challenged by a state department in the Bombay High Court. So Bombay High Court has allowed them to not put 75% of the amount, but they have taken a bank guarantee from that government body, that in case they are forfeited, they will invoke the bank guarantee in the name of Register of Bombay High Court. After HCC versus Union of India, is it okay to just ask for the bank guarantee and not to deposit the money? That is number one question. If you can speak on that, then I will ask my another question.
See, this Niti Aayog proposition of 75% is a persuasive value. It is not binding upon the court. Court can go with its whims. I have seen many arbitration award under 34 in Bombay High Court, where court says, no, not necessary to get a deposit of 75%. Let her proceed with the case. So it is at the discretion of the judges, and you being a legal fraternity as well as engineer, you know how the legal fraternity and particularly court works. So we have no control on that unless there is a law. But Niti Aayog is not a law. It is a persuasive recommendatory value. Arbitrator, judge may accept, judge may not accept. Like in Contract Act, it is said that judge should pursue for arbitration even if there is no arbitration case. But we can't say that he has to appoint arbitrator. He can pursue and say both the party, why are you not going? But you can't compel. So that is the reason it is happening like this. Depending on tunde matir binna, judge to judge, things will change.
Another question is, suppose CPWD and myself is another dispute. Bombay High Court appointed a arbitrator in my case. He has awarded a sum amount. Railways again challenged. That case is started in 2020, before just COVID, and the Railways attorney has not even attached the arbitral award to his original petition. There is no automatic stay, but still judge is not allowing to put 75% of the amount or as good as any guarantee. He is just delaying that amount. So in the execution of decree, there is so much problem for the contractors. So if I try to go into the Vivad se Vishwas, because the arbitrator has given an award, I have to take 60% only.
No, 80%. If 80%. Award is there, 60%.
60%.
If decree is not there, 60%. You get 60% and come out from all the stresses. But that is where I have recommended 75 to 80.
Okay.
So that is where that our proposal should go in such scenario 75 to 80% plus between 9 to 12% interest. We can increase 9 to 15% interest depending on how the BI is going to send final proposal.
Okay, ma'am. Thank you very much.
Chandramohan sir, you can put your question now.
Okay, good afternoon, madam.
Good afternoon.
I'm Chandramohan from Cochin, Kerala. How you have elucidated so far was it perfectly in line with my thoughts, but I have some difference of opinion. That is, hello, am I audible?
Yes, I'm able to hear you.
Okay. See, I have an arbitration award, and the award, while pronouncing the award, the arbitrator himself has told that this is a decree and it is executable. And then if that is so, the difference between a decree and the award should not be there. Right? That's my one point. Whatever awarded if it is a decree, it should be in line with the award of the court as well. And that's number one. And number two, in step 6 and para 9, one second, just need to take. It's in the last para, it is said that the contractor will be given 30 days to file application for withdrawal of the case before the court or arbitral tribunal. But if the appellant is the government, it is silent. And how to deal with that then?
That is what it is, one-sided Vivad to Vishwas. If you ask me, it is not 100% Vishwas. It is a question mark of Vishwas. That is a one thing. The second thing, when the arbitrator is writing that my award is a decree, it is a patent illegality. Arbitrator has no jurisdiction or legal right to say so. Yes.
Oh, he is a retired High Court judge, ma'am.
With all due respect to those judges, I don't want to comment anything, but we know how they work. So less to talk on that. Unless it is challenged, not challenged, then it becomes a decree, is a part of arbitration act only. But arbitrators themselves are not a judge. They cannot write. It will be set aside on the patent illegality.
Okay, thank you.
I have seen Chief Justice of India's award set aside on the remark that non-application of mine.
Madam, we have to finalize certain a few points for the representation also. So questions, those who want to raise the questions may please raise their hands. There are 3 questions are there. I suggest that will be the last questions. Is it okay? If anybody else wants to raise hands, please do it faster. Not Mr. Patil, it is your turn. Please.
Yes, sir. Ma'am, as per the applicability clause, can you hear me, ma'am?
Yes, yes.
Yeah. Yes, ma'am. As per the applicability clause, the claims raised before 30 September 2022 are applicable for this scheme. And further, there is another clause which says that the arbitral tribunal committee for conciliation, etc., for specific case has been already notified by the procuring entity. Generally, this is not in the control of contractor.
No.
Only he can submit the claim. So this the next para should be deleted is our request. What is your
that is what that all redundant part which they have written one-sided.
Yes.
should be deleted. It should be that if the arbitration process is going on, it is as good as notified. Because when you are appointing arbitrator, he is appointing arbitrator, you are participating in arbitration process, or you have invoked the arbitration and you are undergoing a process of conciliation, it is a deemed notification. See, the person who is drafting this has to have as somebody previous participant was talking, that High Court judge has written like this. But sometimes, with all due respect to legal fraternity, my area of construction industry required a specialized training of construction law. And construction law requires different parameter altogether to understand this wording. And we should draft this in a very simple and understandable, unambiguous language.
Yes, that means, ma'am,
yes, that is a well taken point, that how to, but it is a deemed notified. The moment I am in arbitration is a deemed notified process.
Yes, that means only invoking the arbitration is sufficient for this.
Sufficient for this.
Yes, that should be there.
Yeah.
Then another thing, madam, in many arbitration awards, there are 2 types of awards they made. One is where they award some specific amount, and in another clauses they award some declaratory award. So that amount is not specified there, but it requires to be evaluated or computed from the basis. So that amount should also be considered for this.
That for that purpose, it is required to be, so the clause C and D is required to be redrafted in totality.
Yes, yes. Also, there may be future claims also with.
That is why I said that future claim by their agreement which they have proposed are nullified, which should not happen like that.
Yes, yes. That's all. Thank you, ma'am.
Yes, Sanjay.
Raju sir.
Bolo, Madhu. I am.
Niladhari Basu.
Okay. Who is he actually? Mr. Niladhari Basu, can you come to the camera?
Yes, just a moment.
Yeah. In the meantime, Mr. Sanjay Tyagi, आप क्वेश्चन बोलिए. Sanjay Tyagi जी, आपका क्वेश्चन बोलिए.
Yeah, madam, I have
Yeah.
two very important questions of my fraternity.
Yeah.
Actually, we are not a very huge type of contractors here in Ghaziabad. We have small and medium scale contractors. So we were trying for a long period in our department to get the arbitrator, but department didn't allow for it. Finally, we had to move to the High Court and they appointed an arbitrator. But it could happen only in the month of November 2022. So my first question is this, that under this scheme will we fall or we are not eligible to go to this under to Vishwas, to Vivad, to Vishwas?
It will fall under C and D.
Okay, my second question for the C and D, madam. As you have already spoken that these are to be again to be check out. But one thing I must say that many of our contracts, because हम लोगों के डिपार्टमेंट में हम लोगों से कहा गया कि फेक जो इस तरह के क्लेम्स बनाने का आपको कोई जरूरत नहीं है, आप लोगों को उतना ही क्लेम बनाना चाहिए जितना आपका लेजिटिमेट है और जितना आप लोगों को होना चाहिए। तो उसके लिए हम लोगों ने वी हैव फाइल्ड ओनली फॉर दैट अमाउंट विच वी हैव वर्क, मेरा हमारा बिल जितने का हमने काम किया हमने उतने का ही फाइल किया। हमारे जो आर्बिट्रेशंस के हमारे जो पहले जो कंसल्टेंट्स थे उन्होंने हमको बताया कि वी कैन नॉट फाइल फॉर द इंटरेस्ट पोर्शन on that amount which has been stuck for 7 or 8 years in the department.
Why
so,
not?
Yes, my consultant, Mr. Dhanwantral Gupta is here. He was my consultant. He told me that we under the Arbitration Act we cannot claim interest on that portion if it has been stuck for 4, 5 or 6 years and even it has not been paid as so far.
Unless in the contract there is a provision of no interest, you can ask for interest on your bill.
Madam, as you have already told and you know it very well that the contract conditions are completely one-sided.
Absolutely one-sided.
And they have mentioned it clearly that we cannot ask any kind of interest. Yeah, it is there. But it is totally illegal and illegitimate procedure there. So we have filed the claim just only for our work done and मतलब जितना हमने काम किया उतने का ही हमने बिल रेज किया, हमने केवल उसी के लिए आर्बिट्रेशन डाला। अब इस केस में अगर हम सी और डी के स्कीम में आते हैं और वो हमसे कहते हैं कि हम 20% हम ले लें, तो उसमें तो मैडम हमारा जो अपना भी है
that is what I presented, that this is a I did not wanted to use a harsh words, but it is not a Vishwas, it is a Vishwasghat. I'm sorry to use this word, but it is not Vivad to Vishwas.
And one my previous question was that कि हम लोग अगर अक्टूबर के बाद हमें आर्बिट्रेटर अवार्ड हुए तो क्या हम लोग इस स्कीम के अंडर आएंगे कि नहीं आएंगे?
स्कीम में अंदर तो कोई भी आ सकता है, it is up to the government because scheme
as per the norm
they have written that ongoing project, so ongoing project are going on beyond September 22 also.
No, projects has been closed, madam. In 2015, work has already
been done. That is your case. That is your case. But this Vivad to Vishwas talks about all those which are claims are finalized before September, for those which are ongoing work. So ongoing work, how they can say up to September 22?
But as
ongoing is even today ongoing. There is an ambiguity in the draft itself.
Yes, as Dr. Dharmesh Avasthi has explained in the starting, that only those people can go to this scheme who has filed their arbitration.
No, we have to propose that there cannot be a limitation of date.
Yes,
this should be for everyone and each and everyone, whether it is a small fish or a big fish.
Thank you, madam.
They can't restrict to certain people only.
Right. Madam, my suggestion I have written it on the मैंने इसमें लिखा भी था अभी पहले सजेशन में, मैं ये चाहता हूँ क्योंकि हमारे यहाँ जो गवर्नमेंट ऑफिसर्स हैं वो हम लोगों को मजबूर करते हैं आर्बिट्रेशन में जाने के लिए, वो रोकते हैं।
आपके वहाँ का पूरे इंडिया में सब मजबूर करते हैं, आपके वहाँ का सवाल कहाँ है? आप कहीं भी ले लो। आज एक क्लाइंट मेरा आया था, उसको सो कॉज नोटिस बैक डेटेड दी और बोले बैक डेटेड में रिसीव करो, 10 दिन पहले नोटिस मिली थी। मैंने बोला 10 दिन में जवाब देना था और आज मिल रहा है, तो बोले वैसा करना पड़ेगा, नहीं तो बैंक गारंटी एंड कैश करेंगे।
वही मैडम मेरा था कि
ये तो लुक्की दादागिरी है।
गवर्नमेंट को दें तो हम ये भी कहें कि अकाउंटेबिलिटी शुड बी फिक्स्ड फॉर द पर्सन हु हैज मेड अस टू गो टू द आर्बिट्रेशन।
वो होने वाला नहीं है, लुक्की दादागिरी है। इट इज वी एज एन एसोसिएशन हैज टू गो to court for all such problems. That first our contract document must be streamlined properly.
Okay, madam.
Why for developers, Supreme Court is saying frame the contract document? Why not construction industry?
Basu sir, do you raise your question, please?
Yes. Good evening, ma'am. So,
Good evening.
yeah, I agree with your points that for scheme A and B it should be much more percentage because you are already awarded degree. So one thing I want to know that so that we are fighting on interest rate also. So there should be a time limit for disbursement of that money. It cannot go on forever. When there should be a time limit because our money is, we are not interested in the interest. We are interested in the total money. So there should be a timeline for that.
We should propose timeline and say that within this period, if it is paid simple interest of 12%, beyond that it will be compounded.
Whatever it is, but we need the full amount. That is more important
Yes,
to us.
that is
This
more
one
important.
thing.
We want money in hand.
Yes. So second thing is that suppose the scheme comes into force, is it mandatory to go for the scheme or is it an optional clause?
It depends on how the government is bringing this scheme. If the government says it is compulsory, we have no choice. If it becomes an act, or if it is like Niti Aayog recommendedly. If they make it compulsory, we can go under writ petition to Supreme Court, restraining legal rights.
So we should from the
And we should struck down. Association can go for writ petition in Supreme Court.
No, but,
because it is my constitutional right. They are hitting my constitutional
we should
right.
put it as that I should go as
Yeah.
a recommendation, not
Recommendation.
as a binding on
Mandate.
the contract.
No.
Is the option.
It's an option.
Personally, I feel it won't be mandatory. It won't be compulsory because nobody can, compel a person to accept the scheme of the government. It is like a settlement scheme. That is what.
It's a direct attack on my constitutional right.
That is why it won't be there. Anyway,
It can't be.
Jokers up, your question, please. Unmute yourself.
Unmute yourself. Jokar sir, unmute kara स्वतःला.
Good evening.
Good evening.
Dr.
How
Vandana
are
ji.
you? How are you?
Fine,
I'm
fine.
fine. After
Very
long.
very happy to meet you this evening.
Thanks a lot.
Vandana ji, again coming back to your today's subject, Vivad se Vishwas tak. That means government is accepting there is some Vivad.
Yes.
And that Vivad is from the contractor. So they wanted to give some Vishwas and resolve this, whatever our claims are being there. Now my question, very important question, in that structure or condition, why this counter claim is being accepted by the government?
That is what is my first objection. In my speech, I said that I am not accepting counterclaim in toto. And that is why C and D I am not accepting. A and B I am accepting because it is adjudicated. Award is passed, rightly or wrongly. But claim, counterclaim is done.
You are 100% clear, but by accepting the counterclaim, this settlement doesn't come to the
No, it's a blackmailing tactics, backdoor blackmailing.
So what is the resolution? The counterclaim.
Resource that we should not accept C and D. We should send as a BI our proposal that C and D should be changed accordingly.
Right.
That is why I said C and D is not acceptable at all.
Okay,
thank you very much, Vandana ji. Let us meet earlier.
Thank you. Yes.
And wish you best of health again.
Yeah. Thanks a lot. Thank you very much.
Okay. Kashi Vishwas sir, आपका है. You please.
Namaskaram, madam.
Namaskar.
Hello.
Madam, in my case, actually, we gone for against the state government. We gone for adjudication. The adjudicator was awarded some claims in favor of me, but again, the department has invoked the arbitration against to adjudication award. Again, arbitrator also given award in favor of me. The same is processed by the department. It's gone to different levels and it's gone to finance department, and finance department also agreed. But later on, the process is stopped by the administrative department. It is not processing. Somewhere it stopped. What can I do? Actually, everything is completed, but we are unable to receive the money, madam.
See, if it is a 90 days over after the award, go for execution petition, because award under the law, not by the arbitrator, under the Act of Arbitration Act, become a decree after 90 days. if it is not challenged.
Oh, it is not challenges. The
And
challenge.
then go for execution petition. Go for execution petition.
The challenging period is also over, madam. It is.
So go for execution petition and put a application that chair should be confiscated.
To whom, madam?
Very
By
easy.
court only? Execution petition should be filed in court or
Court.
court, high court, madam, local court.
It depend on what is the jurisdiction in the contract.
Okay.
Yes.
Thank you. So is this visa, this scheme is applicable to both the state government also, madam?
It should be. So far, there is ambiguity on that. So we have to simply say wherever the public money involved, this scheme should be implemented. Simple, no ambiguity in the words. Otherwise, we'll say, no, this corporation is not that corporation, it is not applicable to me. I'm not coming under that scheme. Government will start doing that business. So to avoid this, make a simple language. Wherever the public money is involved, this scheme is applicable.
Thank you, madam. Thank you.
Mr. Reddy साहब, आप बोलिए, आपका क्वेश्चन पूछिए रेड्डी साहब.
रेड्डी साहब अनम्यूट कीजिए खुद को.
Yes.
हाँ.
Actually, I don't have any question. Why? Because all our brothers already, I don't want to repeat also that, you know, जितने भी हमारे भाई लोग सब पूछे हैं, फिर वही रिपीट करना तो मेरा ये नहीं है. और माँ जी, हमारा वंदना जी, there is no words to appreciate you because of at least you are our BA side, and now we are the business. We are the business in the building, all those things. The builders of modern India, in fact, we are contributing to the global development and global economy. In every convention, every meeting, bureaucrats and politicians and technocrats use the words as we are the builders of the modern world. But in actually, as a stakeholders, we have been ill-treated. Please give consideration to at least see as our treat as a human beings. I humbly request all this every forum and politicians and you, including you, this August meeting to give an applaud, to give as a respectful treatment. Please, I remain with emotion because I care for humanity. ये independence और विश्वास में ही है. There is a thank you.
Thank you.
Okay, Chandravan sir, you have one more question? Please unmute.
Madam,
Unmute.
This is the last question. This is the last question.
Madam, this
Anybody
is
else one minute, Chandravan sir. Anybody else want to raise any question? Avasi sir, you want to raise question or you want to discuss, speak something? Okay, Chandravan sir, please go ahead.
Madam, this is a technical question. See, when an award is passed, can the department accept a part of it and pay and disapprove a part of it?
I can't hear you. Can you repeat, please?
Hello, can you? Am I audible now?
No,
Yeah.
Ask Chandravan sir. What he is
Yeah.
asking. What he is asking. 1 minute, Chandravan sir. Ask actually. Your sound is echoing. What his question is, if an award is there, whether the department has the right to give part, whereas they will say the other part we are not agreeing. Is it possible? Partial acceptance of award is possible or not? Is it right?
You can take it without prejudice or under protest because money in hand is much better. Why to allow them to not to pay you? If they are ready to pay you 5 rupees, take the 5 rupees and fight for 95.
That's a good suggestion.
But don't give away your rights if you are not agreeing to part payment.
Take the money.
After all, this is a business decision. These are commercial decisions.
No. Okay, that but whether there's any technical provision for that, if they approve even 1 rupee of the award, one part of the award, can they legally in a position to challenge it?
They can within the limit. They say we agree up to this and this. Why they do that? They want to avoid interest on that 1 rupee.
That's what my question is.
Yeah, they want to avoid interest on that 1 rupee.
Part of it is approved, that part is not approved.
I was ready to part with 1 rupee. He has not taken. So court will look into that in a public interest litigation type thing. Under public policy, they will not pay you interest on 1 rupee.
Okay.
So
Okay.
take
Okay,
that
thank
1
you.
rupee. Take that 1 rupee
Thank
and
you.
fight.
Thank you,
Sir, you please unmute. Sir.
Yeah. Am I
Yeah.
audible now?
Yeah.
Last small point, like having said so, and let's see.
There's some echo is coming, sir. Could you please check with the instrument? I think some echo is coming.
I don't know from where it's coming.
No, previously you were talking well. When you were speaking at the beginning, it was good. I think you can remove that earphone and all. Maybe it is causing the issue.
Is it okay now?
Yeah, now
Yeah.
it's okay. Go ahead. Yeah.
Okay. Now, the last point which I wanted to say, having accepted the scheme and got billing and not but the last point is, when this scheme goes to autonomous bodies of the central government like India and a couple of other institutions, there is a board. And that board has to not be accepted. Otherwise, what happens? All said and done, without implementation, implementation of the scheme, the officer concerned were to sign it. They are always vigilant about some vigilance will go on and so on and so forth. There should be some way if they identify those officers, and that can be done by the board, which is what our mentioned. Somewhere in between, I think we should mention it so that having done all the exercise, the work on this scheme, let it take final shape. That's what I want.
For that, government has to come out with the Vishwas in their own engineer.
Right. Absolutely right.
So
That-
not only Vivad to Vishwas with us, but Vishwas to Vishwas also should be there.
But unfortunately, their own engineer do not.
That is the problem. That is the problem. Engineers are putting up counterclaim to save their skin. There is nothing like that. They agree कि सब arbitration में जाके ले लो ना. आपके मुंह पे बोलेंगे कि हम मानते हैं आपका नुकसान हुआ है, लेकिन आप जरा arbitration का कोर्ट का ऑर्डर लेके आ जाओ.
इसीलिए तो बोलते हैं कुछ इंजीनियर बहुत अच्छे होते हैं, ऐसी
होते हैं, कुछ नहीं, मेजोरिटी अच्छे होते हैं साहब, मेजोरिटी अच्छे होते हैं. आप मुझे पूछेंगे तो गवर्नमेंट के इंजीनियर्स अच्छे हैं, उनकी सिस्टम खराब है.
That's all.
Thank you.
Raju sir. Unmute, Raju sir, unmute.
Yeah, please. Madam, do you think we have to form a committee or similar things of giving a representation today? Or do you want to tell the people to send their points in writing? What is your proposal?
My proposal that because we have lot many members, let them send you email with their what is their perception, and then form a small committee who will go through all these proposals and prepare a aptitude draft to be presented to government.
8th is the last date, ma'am. So today is 27.
You can tell them that by 1st or 2nd they can send their email. On 4th, 5th, like Sunday is there, everybody will be free. You form a small committee. Let that committee meet and analyze the proposal and draft it.
President sir is there. Madhu, could you please
No,
check?
Raju sir, President sir is not there.
Then members, I think madam's proposal is excellent. Let us accept it. By 2nd or 3rd, if you can send us the proposal, then we can finalize it so that by 8th, it will be reaching to the concerned ministry. In principle, we can agree what the government said first, 1 and 2 points. C and D, we will give our reservation, particularly on the interest portion. We will be giving our suggestions very strongly. And also, as ma'am rightly said, we will be going for a standard contract document where that is a long-standing request of BA. Let us try this time that also. If members agree, let us go for the vote of thanks. May I request Mohinder Rijwani sir to propose vote of thanks, please.
Good afternoon, everyone. Respected members and my dear friends, it is a great honor to propose the vote of thanks to all who have helped us in making this webinar successful. First, I would like to thank our President Shri Nimesh Bhai Patel for gracing today's webinar. Thank you, sir. I would like to thank our distinguished speaker, Dr. Vandana Bhatt, for briefing us the scheme Vivad se Vishwas 2 in detail and making this webinar interesting and meaningful. Thank you, ma'am, for sparing time from your busy schedule. I would like to thank members for joining us for this webinar. I would like to thank our BI staff, especially Raju John and Madhusudan, who have made this webinar successful. And I once again thank you all for joining us here today. Thank you.
Thank you very much for inviting me.
Thanks a lot. You have made
Welcome, ma'am.
Thanks a lot. Thank you very much for giving me opportunity.
Oh, the presentation
Thank you,
was
madam.
excellent.
Only a small correction. I am not a chartered accountant. I am a chartered engineer.
Yes. You
I
are-
was introduced as an accountant, but I am not. I don't know ABC of debit credit.
Thanks, ma'am. It was
Thanks a
ma'am,
lot.
for
Thank you very much. Thanks a
accepting
lot.
my
cleared-
invitation for this
you have
webinar.
cleared
Thank you very
many
much.
issues
Thank you,
very,
sir.
very nicely.
Everybody can unmute and share their thoughts. Everybody can unmute and share their thoughts. Unmute themselves. They can unmute themselves.
Bhatia or somebody at the end came with a question. Is he? Can he?
No, 1 minute.
Patel sir, Natubhai Patel sir.
Just
Question
It's
is-
okay. It's okay. Sir.
Raju sir.
Boliye.
We had participants from Mauritius and Sri Lanka also.
Very good, very good. They can also ask questions. Madam is waiting. Yeah.
Rohanji, Mr. Rohan, are you there? I think he left. President sir has come.
Acha. President sir has come. Can you make him to the main screen, Madhu?
Raju Janji, very excellent presentation. Very good views given by madam. Very
Thank
nice.
you. Thank you. President sir, Madam was President sir, Madam was telling by 3rd we should get the proposals ready so that by 5th again a small meeting can be called or a small committee can be formed. Thereby we can give the final proposal to the government by 8th. This was the proposal.
Okay.
Please give permission for approval for this.
Yes, go ahead, Rajujan, please.
Thank you, sir. Okay.
Thank you, madam.
Madam that madam has
Thanks a lot.
churned our inspiration regarding this arbitration. I really thank madam from the core of my heart. I am a member from the northeastern state from Silchar. This is Brajesh Tushniyal.
Madam was wonderful, sir. Today, President sir, Madam was very wonderful as usual. Our members are impressed. Most of them saw even raised questions too. So, if everybody agrees, we can leave. Madhu?
Sure.
Yeah.
Yes, you are Rajuji. Thank you.
Okay, thank you.
Thank you, Vanda madam.
Bye,
Thank
everybody.
you very
Bye.
much. Thanks, everybody. Thanks for everyone.
Thank you very much.
Thank you. Thank you.
Our sir, thank you.
Thank you, Raju bhai.
Thank you.
Thanks, Madhu.
चल bye bye. End करता हूँ.
आज एंड कर
नटू भाई पटेल साहब.
नटू भाई साहब किधर है?
नटू भाई है ना, नटू भाई है.
How are you, sir?
Fine, sir.
Okay.
It's nice, interesting.
Yes. Madam has said more interesting.
Yes. Vanna madam very clearly said so many things.
Yeah.
Sir, this is Brajesh Tushniyal from Silchar.
No, I was expecting more participation, in fact, because this being a very crucial subject, the participation was not up to the expectation accordingly.
Very, very true, sir. This is
Raju sir.
Sir.
Raju Madhu here, last 4, 5 or whatever, even more webinars which we have been in the center or committee. These, from my standard, these attended is fantastic.
Yes. We have got 70 today.
This attended is fantastic.
Achha. How many people are there? How many was there?
Around 70.
I think those people are going and coming. We touched 100.
It was
100 participants, more than 100% have joined, but not at one time.
70 or 70.
70.
कितनी टक्कर साहब?
को भी चाय भेजो ने.
70 or whatever.
चाय कौन मांग रहा है?
चाय पे चर्चा करो कुछ.
Raju sir,
Thank you so much.
Yes, sir.
Raju sir, one more question.
Brajesh Tushniyal from Silchar Center.
मैम ने जो बोला कि
Assam.
2 तारीख तक प्रपोजल सब भेजने हैं.
ब्रजेश जी आपका कैमरा ऑन कीजिए ना.
Madhu,
मेरा
Would you mind? Supal sir was one more question. बोलिए sir.
राजू जी, जो जैसा मैडम ने बोला वैसे जो भी प्रपोजल हमने सजेशन ऑब्जेक्शन जो भी है वो 2 तारीख तक आपको भेजने हैं हेडक्वार्टर्स.
Yes sir.
And after that we will make a representation to the government.
Yes sir.
Okay sir. So we accordingly we will send our suggestions, sir.
Please.
Thank you.
Thank you,
Raju sir, thank you.
Thank you.
Thank you sir. Thank you.
Thank you everybody. We are ending the meeting. Brajesh ji, you are from Northeastern. You have our email ID, na?
Yes, I do have. I received your mails also. It is registered with BI.
ठीक. Please send to Mr. Raju your queries.
Please send your proposal also, sir. If anything is there, please send.
Sure, Raju sir. Sure, Raju ji.
We will be appreciated. This will be very good in case more members can send the proposal.
Yes, because the Northeast states is the biggest sufferer. Here the officers and engineers, they don't want to understand.
We have Mr. Kaul from Arun Gupta's office. Kaul sir. How are you? Oh, unmute sir, unmute. Kaul sir, unmute. Please unmute sir.
नहीं राजू ही नको.
अच्छा, okay.
नहीं, he earphone नहीं है. चलो बंद करते हैं मैं.
Please करो ना please. Yeah. Okay.
Bye.